I'm real pleased today to introduce us the speaker, Roxanne Ryan. She's the Commissioner of the Department of Public Safety. She joined the department in 2006, served as a lawyer for the department, and served as a criminal intelligence analyst in the department. Before joining the department, she was a full-time professor of criminal justice, an assistant attorney general, and a deputy attorney general. She teaches as an adjunct professor at Drake Law School and Simpson College, graduate of Iowa State University, the University of Iowa College of Law, and the University of Nebraska, where she earned her PhD in criminal justice. Commissioner Ryan and myself both started together at the Attorney General's office a number of years ago, and so it's a pleasure to welcome her to this CLE today. Thanks, Roxanne.
Thank you. Well, I have to say the most interesting job that I've ever had was as an analyst, and one of the reasons was that we talked a lot about technology, and one of the issues that we have with technology, if you're in my generation, because Mark and I did start a long time ago at the Attorney General's office, people in our generation tend to be a little bit like the Luddites, opposed to increased industrialization, or the key part, new technology. And there are some real advantages to Luddites because life is a whole lot easier for them in many ways. But I don't think it's really a choice for lawyers. We do have some ethics obligations that get in the way of being a Luddite because the rest of the world is not, and we are providing advice to clients who are not Luddites. And the primary rules that are implicated for ethics, the first is competence, the second is diligence, and the third is confidentiality and communication, because we have to protect privileged information, and we need to protect confidences and secrets even if they are not privileged. So understanding how technology works is an ethical requirement. So what do you need to know about your own computer network? And if you're providing advice to your clients, you probably need to know that about their computer networks as well. The things that I suggest that you should pay attention to, and you don't have to understand all of these things, but you do need to make sure that your technology experts understand them so that they recognize the need to have the most current and the greatest protection in the systems that you have in your law firm, or if you're representing a government agency, in that government agency, and the information that comes to you also has some implications in terms of particularly the confidentiality of the information. Sometimes hacking is a serious concern, sometimes inadvertent sharing is a big concern. But the things that I suggest that you take a look at is what kinds of connections do you have, because the connections can have an enormous impact on people's access to the types of information that you're sharing across that connection. Landlines are the safest. I know a lot of people don't have landlines. I still have a landline at my house because occasionally when I'm talking to federal officials, I can only do that on the landline. You want to talk about paranoia? Their paranoia probably is greater than anybody else's, and with good reason. DSL and Wi-Fi are probably the most common that we see, and the DSL is similar to landlines in terms of security. Wi-Fi, on all of my devices, I turn off Wi-Fi, and I choose which Wi-Fi I'm willing to use. I don't inadvertently hook on to free Wi-Fi. I never hook on to Wi-Fi at hotels or any other public locations. It endangers any of the information that you might have. We do have some satellite connections. The satellite connections generally are fairly secure. You also need to make sure that you're paying attention to all of the devices that you have and how they are connected. If they are connected in a secure way, you have a whole lot more protection of the confidential information, and you certainly need to be aware of all of those devices. For those of you who represent governments, the one thing to really keep in mind is that in addition to any devices that you might issue through the government, you should think about what your policy is about sharing that information from one device to another. So if people are sending something from a government email to a private cell phone, that may well create some concerns. Government agencies are often targeted by hackers, and so I know in our department our policy is that you are not supposed to be forwarding anything from your government email to your personal email. Keep that in mind as well if you are trying to protect the confidentiality of your client's information. When you are sending it over the open internet, or what we refer to as the dirty internet, you're taking chances with that information, so you really have to be very careful. Another piece is storage. Hard drives, any secondary storage that you might have, the security and the encryption that you use in those devices can certainly have an impact on the security of the information that you have there. Cloud computing is another one to really be careful about. We'll talk about that a little bit more later on. Also, your backup options are going to be extremely important, and again, cloud-based storage is a significant concern. Security procedures are very, very important for how people operate their own devices, how the system is operated, what kinds of encryption is required, what is workable for you on your system, what policies you have in place, and whether people are actually following those policies and actually protecting them. So in terms of ethics, your competence requires that you know enough to ask the right questions of your technology people, that you are diligent in making sure that you're providing the kind of security and protection that you should when you have sensitive information, regardless of whether it's privileged or not. It may be sensitive. It may have implications for confidences and secrets that go beyond privilege. So one of the other things to look at is virtual private networks. Our general policy in law enforcement is that we don't share information over the open internet unless it's information that we don't care who has that information or not. If we are sharing any kind of law enforcement sensitive information, our practice in Iowa is to encourage sharing through a virtual private network. I think for lawyers that's a pretty good standard as well. You should know whether you have a virtual private network, either within your own law firm or within your own government. If you're representing that government, you should know where your information is going and who may have access to that in order to adequately protect the security of that information. So if you are not if you're technology resistant like I am, the questions to ask your tech people are, what kinds of security do you have on your system and on your devices? What kinds of connections do you have among the various devices? How much information is going to be shared over the open internet? How much of it is going to be shared through virtual private networks? If it is shared over the open internet, then you really need to be looking at encryption if you want to be able to protect that kind of information. There are some fairly simple encryption programs. There are some much more complex encryption programs, and you need to have that conversation with your tech people to figure out just exactly how much protection you need and how it's going to work. One of the issues that we run into is that when you have encryption, that's great. You also have to be able to decrypt, to de-encrypt the information. And if you are doing that, if you're in a government agency like I am, we get public records requests on a pretty regular basis, which means that if we are storing information in an encrypted fashion, we have to know whether that encryption program allows us to search. The same is true if you're looking at discovery. So when you're talking to your tech people, you need to find out what is encrypted and what kinds of search capability do you have when the information is encrypted. If you are going to store it when it is unencrypted, then you have to think about the security of your storage. For those of you who have security clearances through the government, you're probably familiar with the OPM data breach. I was one of the victims of that because I have a federal clearance. All of the information, and you have to submit it essentially an autobiography to be able to qualify for a clearance. All of that information was stored separately, but it was connected to a system that was hacked. Could have been taken care of pretty easily by simply disconnecting the storage area from the network. But that was not done, and it was hacked, and a lot of personal information was shared with the hacker. I don't know that they've ever actually said publicly who the hacker is, but pretty sure it's people that we really don't want to have all of our personal information. If you are emailing information to clients, it is important for them to understand what privilege is, what is confidential, what is secret. If you're sending information over the open internet, your security is extremely limited. And if it is, I love Google, I love Gmail, and they have a lot of storage. I would never use Gmail for anything related to my work unless there are other protections. The free Gmail is not particularly secure. There are lots of other options. The great thing about Google and Gmail is that they have a lot of other things that they can add. But if you're using a free Gmail account, you should not count on a high level of security for that. I will say, from a law enforcement perspective, it's difficult to get information from Google, so they do protect the information fairly well, but it goes over the open internet, so that's where you run into the hacking concerns. If you're sharing information with clients and you are sending it in any way other than through a virtual private network, you really should have written consent from them. And you should also provide them with the information about what the risks are if they are sharing personal information over the internet. It's also, I think, from my perspective, and I know I'm probably more paranoid than most other people, I don't share social security numbers or other personal identifying information over the open internet. Also important to know who monitors the intrusions to your network. For those of you who work for government agencies, it's extremely important that you make sure that is carefully monitored. Governments are frequently targeted, so you need to make sure that you have consistent and persistent monitoring of those networks. It is becoming increasingly common for government networks to be the subject of malware of all varieties, including ransomware, in which they lock up your system, and the only way that you can get the key to open up the system is to pay a ransom, and sometimes those ransoms can be very expensive. So monitoring the intrusions are very, very, very important. Again, I mentioned the virtual private networks and the restriction of the use of personal emails or open internet. One of the issues that we run into regularly is that the IT people are very logical people. They're very good at what they do. They don't really have an appreciation for what the ethical concerns are for lawyers. So it's important to be able to, when you're speaking different languages, to make sure that you're sharing with them what your ethical concerns are for that. So if you are allowing remote access, for example, that's really convenient, but you need to make sure that you have a good enough firewall. The same is true when we talk about access to the open internet. Firewalls are important to be able to protect against intrusions and to make sure that your network is going to be protected. Password requirements are important. And you need to have robust passwords. 1, 2, 3, 4, 5 is not a good password. A, B, C, D, E is not a good password. Your first name and last name is not a good password. You know, all of those kinds of things, and people need to make sure that they are actually following that. Whoever it is that manages your IT, you need to know who that is. You should know who they are, whether they can truly be trusted with sensitive information, and you should have policies on access to Wi-Fi, particularly free Wi-Fi. That is extremely dangerous and often overlooked. Any personal identifying information really should not be sent over the internet except through virtual private networks. We also have a dark web and a deep web as part of the internet. Those are places on the internet that most people don't have access to, or at least don't know how to get to. The dark web is a place where a lot of nefarious activity goes on. It may be terrorism related, sometimes it's just simply criminal activity. A lot of the child pornography cases that we see are occurring in the dark web. And the deep web is something that it's not going to show up on your traditional Google search or Bing or Yahoo. There are some deep web search engines that you can use to get to the deep web. And some of that, it just requires a password or some other way to be able to get to that. Generally speaking, you're only going to have to worry about the general open internet. Now, in terms of your email, one of the concerns that we have is sharing anything that's related to social security numbers, dates of birth, other personal identifying information. It's relatively easy. If you're a tech person, it's relatively easy to hack into email to be able to get that kind of information. Encryption is one way to protect that. If you have any kind of Adobe product, a PDF that is more than just the free Adobe, you probably are going to be able to do some level of encryption. It may be a fairly elementary type of encryption, but it certainly is worth doing that so that it is at least password protected. It provides a little bit of assurance on that. You can also do far more robust kinds of protection and encryption to be able to do that. So obviously we want to protect all of the confidential sensitive information. In terms of diligence, it's important to know what the risks are for you and for your clients. If you're doing business with people who are on the cutting edge of trademark, copyright, patent, new invention kinds of things, the protection of that information is particularly important. That's another piece that is often targeted, and so you really, if you are dealing with that kind of work, it adds to your ethical obligation to make sure that that information is being protected. For those of you who represent government agencies, keep in mind that a lot of your economic development is also going to have some implications for those emerging technologies and those emerging industries. So you probably are going to have a lot of that very, very sensitive information that is going to be expensive if it is taken without your knowledge. You can also avoid unnecessary costs and damages. Once you're hit by ransomware or some of the other malware, it's going to take a lot of time to get it fixed. It's going to take experts to be able to address that. So if you are, it's a whole lot cheaper to provide good monitoring than it is to try and respond after everything has gone the wrong direction. Obviously, you need to meet your legal obligations, so you have to be able to search and be able to respond to discovery requests. You also need to know and be able to tell your clients about some of the hidden information that you have, either in the networks or in the documents. So you need to know what metadata is so that you can talk to your clients about whether they regularly store metadata, and if so, what kind of metadata they store, and before they send it out to someone else, what kinds of things they are doing in order to strip metadata from those documents. We've got a lot of cases in which metadata has put clients at a big disadvantage when it turns out that they have either not remembered things correctly or they have consciously remembered things wrong. So when you're providing advice, it's important that you know some of those issues so that you can adequately provide advice to your clients. Just to give you some sense of what it is that we face in terms of cyber attacks, the trends of attacks, this is from January of this year, daily attacks. We're seeing a lot of those kinds of attacks. And when you look at 2014 versus 2015, and well, going back to 2012 through 2015, you'll see that there's a lot of variation. If you do any public health work, you can see that sometimes it's kind of like an epidemic, that you see an epidemic of one kind of malware, one kind of attack, and then it peaks and then they move on to something else. So that's fairly common for that to happen. In terms of the distribution of the targets of cyber attacks, government is the most often attacked, and industry is number 2. So government collects a lot of personal identifying information. It also collects a lot of sensitive information that may be important to foreign governments or to domestic groups that are interested in finding out what the government is doing. But really, I think most of the time, the attacks against the government are focused on personal identifying information for the financial value of that. The attack techniques, the majority or the largest number is unknown, that they don't know what the attacks are. That's probably a reflection on how well we are monitoring our systems. The distributed denial of service attacks, the DDoS, that's where you are peppered with email. Back in the day, when people were using fax machines on a regular basis, they could set it up so that your fax machine would just be printing things out forever and ever and ever, and the only way to fix that was to unplug your fax machine. You can do the same thing with email, and that seems to be much more of what happens now. There's so much email that it just shuts down your email system. So that's one of those, when you're monitoring, you certainly need to be prepared for that. You also, if you're working for the government, should have a plan in place for what happens if you do have your network shut down, your email network shut down. I would suggest for those of you who are either in government or working with government, you should consider the Regional Information Sharing System, the RIS system. There's for those who are part of law enforcement, you can have a RIS account. That's a virtual private network. For those of you who do business with the government but are not law enforcement, you can also have a RIS ATIX account. That allows you to use the RIS private network as well. So if you can access the internet, you can access RIS or RIS ATIX. So I would recommend that you take a look at RIS or RIS ATIX to be able to do that. Notice that we also have a fairly substantial amount for account hijacking, which is another one where they just take over your account and take advantage of whatever they can. Motivations primarily cybercrime. They're usually monetary. Hacktivism is 12%. That's still fairly substantial. And cyber espionage is 10 or 11%, and cyber warfare is a pretty small percentage of that, but most of the time they're looking for personal identifying information or financial information so that they can make some money on that. And that includes getting some of the information that's related to trademark, patent, copyright, those kinds of things. Cybercrime in the United States is certainly the biggest concern that we have. There's a lot of money that changes hands through electronic means these days, and so we are ripe for a whole variety of different types of cyber crimes. The energy company BP says it has 50,000 attempts of cyber intrusions a day. Pentagon has 10 million attempts a day. National Nuclear Security Administration, 10 million hacks a day. The UK says 120,000 cyber incidents a day, about the same as the state of Michigan. Utah says it faces 20 million attempts a day, and that's up from 1 million from 2 years ago. I guess I haven't checked recently with our IT people, but at one point more than half of our bandwidth was spent fighting off attacks at the Department of Public Safety. So your IT people really need to be paying attention to those kinds of things. So when we talk about cyber attacks, one of the other concerns that we have for law firms is that because you do have access to a whole lot of sensitive information, including financial information and personal identifying information, lawyers are often targeted. And that's why it is so incredibly important for you to get to know your IT people and have them understand what your concerns are. The ABA has tremendous resources for you, and I certainly recommend that you take a look at the ABA website if you want to learn a little bit more about cyber attacks. Notice also that people tend to lose or not keep track of some of their devices. The great thing about small devices is that you can put them anywhere. The bad thing is that you can put them anywhere and forget about them. So password protection is important. If you do the thumbprint, that's actually probably better than any of the passwords that you might be able to make up because those fingerprints are much harder to come by. Password protection is absolutely essential that you do that. 150 hacking incidents in the previous 12 months. That was in 2013. Way more than that now. The cost of investigating, mitigating, remediating is $1,000 an hour. So those IT people are extremely valuable. Pay attention to them. Lots of other stats that talk about the targeting of law firms. It just continues to increase over time. We also have fraud that is specifically targeted at law firms. So a number of them, and we've had these cases in Iowa as well, something that looks like a legitimate solicitation email from a prospective client. The lawyer checks, they negotiate, they have a written fee agreement. So you've established your attorney-client relationship. You receive what looks like a valid cashier's check from a reputable bank. The client requests immediate distribution of the settlement to a foreign account and approves the attorney fees to be deducted. The lawyer retains the fee and then wires the balance to the foreign bank account, but the cashier's check was fraudulent. So you really have to make sure that if you are dealing with someone that you don't know personally, that you are doing due diligence to check on them, because we've had scams where it's been tens of thousands or hundreds of thousands of dollars that have been taken from lawyers as part of this scam. The other thing to really keep in mind is when you're traveling, particularly when you're traveling overseas, many of the carriers, the cell phone carriers, will provide you with a travel phone. The hacking concerns, and particularly if you use free Wi-Fi anywhere, and Wi-Fi is different outside of the United States than it is here. Always best if you either take no phone at all, or if you take a clean phone that limits the information that is available on your phone. If you lose the phone, of course, that can be dangerous. So the less information you have on the phone, the better. There are encryption programs that you can buy that will allow you to access your computer remotely and essentially bring your virtual private network with you wherever it is that you go. So if you're taking your computer, keep that in mind. It's not a bad idea to do that within the United States, but it's even more important if you're taking it outside of the United States. Protecting all of that critical business information is very, very important if you're going to be confident and diligent and maintain privileged information and confidences and secrets. So in terms of confidentiality, I've mentioned encryption a number of times and virtual private networks. If you don't have those, think about whether that's going to be an option for you. There are a lot of different variations on both encryption and virtual private networks. Absolutely the best way to protect the information and to protect yourself. Particularly important for lawyers to be able to do that. Keep in mind that the confidentiality obligation attaches when you agree to consider representation. So if you are advertising online, be very careful how it is that you are encouraging or discouraging people from sharing information with you. If it turns out that you have a conflict, you want to make sure that they are not sharing information that's going to create a problem for you. If it turns out that you're representing the other side, the attorney-client privilege applies to communications between the lawyer and the client, but if they are sharing business information, personal identifying information, you need to make sure that that's protected as well. You are supposed to take reasonable steps to protect confidential communications. You don't have to have special security as long as there is a reasonable probability of confidentiality. If you are sending things over the open internet unencrypted, I don't know that that is reasonable to expect that it's going to remain confidential. So be very careful about that. The other thing to keep in mind, personal use and personal behavior does not always have professional ethical implications. Occasionally it does. It's not entirely exempt. And occasionally you'll have the personal and the business coincide. So we have one, this was actually a screenshot from the internet where someone had his mugshot that showed up right next to an advertisement for him for his law firm. So we do have an ABA opinion from 2011 that talks about confidentiality of emails. You ordinarily must warn the client about the risks, and when the lawyer knows or reasonably should know that the client is likely to send or receive communications, that the client needs to understand that there is a significant risk that the communication will be read by the employer if they're sending it from their work email or by another third party. So if the confidentiality is breached, then that information may have to be shared, and you really should be having that conversation with the client. Same is true for the Iowa ethics opinion. When we talk about computer security, you do have an ethical obligation to make sure that that you are aware of potential misuse of the firm's systems. You have a duty of due diligence to assess your system security, and it requires due diligence, not a specific result. So as long as you are making appropriate efforts, you'll meet the ethical obligation. One of the other things is an attack. This was an example in 2012, an attack from the group Anonymous on a website, on a lawyer's law firm, on their computer system, because the attorneys were representing someone that Anonymous was not thrilled with. And so they hacked into the attorney's system and said they stole all of the emails and client information, and they may have the ability to send emails by impersonating the lawyer and thereby seeking out additional information. So who your clients are can have an impact. And if you're representing the government, you may have noticed Anonymous is not a big fan of government. So they may very well be attempting to attack your government clients as well as private clients. When you receive a copy of the third party's email, because of course a lot of times we're sending emails inadvertently to people that we don't intend to send them to, if you are getting somebody's email, there is an ABA formal opinion that talks about that. The ABA says that there may be some notification duty based on court decisions, civil procedure rules, or other laws, but there is no law that establishes a notification obligation for an inadvertently received email. I don't recall that we have anything from Iowa. Oh, I take that back. We do have one decision or one ethics opinion from Iowa that says the opposite, that there is an obligation for you to notify the other attorney and return whatever it is that they have sent to you inadvertently. The other thing to keep in mind from a cyber perspective is HIPAA. And it can have an application to law firms if you are acting as a business associate. So if you're practicing health law and you represent covered entities, you're providing legal services to or for a covered entity, an organized healthcare arrangement in which that covered entity participates, and you're providing legal services to or for another business associate, then that may have some HIPAA implications as well. And if you are receiving personal health information from a client, that also may have some HIPAA implications. And there's an omnibus rule that defines the business associates that makes it pretty clear it can include law firms. So be aware of that. It certainly has some potential for problems under HIPAA. So the example that's given that there are a couple of law review articles that are written about this. Your firm represents a physician group appealing a post-payment audit involving several hundred patients after copying the medical records of almost 600 patients to a personal flash drive. You ask your assistant to deliver the records to a billing consultant, but your assistant has dinner plans, so she drops the flash drive in her purse, intending to deliver it before work the next day. Unfortunately, your assistant forgets her purse at the restaurant. The purse and the flash drive are never recovered. Your client, likely your former client now, must contact each of the affected patients, publish notice of the incident in the media, and notify Health and Human Services. Additionally, your client may seek reimbursement from your firm for any government fines and the substantial costs that it incurred in sending the notifications and hiring you counsel to advise it on the incident. And HHS may elect to impose an additional fine on your firm, and the HIPAA insurance policy your firm carries probably excludes personal devices. So be very, very, very careful about anything that may contain medical records. Again, think about encryption. It is possible to encrypt small storage devices, and that makes it much less likely that people are going to be able to break into that storage device and obtain the information. So if you look at the HIPAA violations by types, the data physically stolen is the majority, 55%. So if you have that personal health information, the physical theft is what you need to worry about the most. Encryption can take care of that. And encryption of all devices is the way to go. Anything that can be carried can be encrypted, and probably should be as well. I think I mentioned that one. One of the other concerns that we continue to have when we look at the cyber issues is social media and the information that people put online. So one of the questions that comes up fairly often is, what about jurors' internet presence? What kinds of background information can you find out about those jurors? And there is an ABA opinion from 2014 in which they said that a lawyer can review the jurors or the potential jurors' internet presence, which includes postings by the juror or potential juror in advance of the trial, but you can't friend them on Facebook. You can't make connections with them other than looking at what it is that they have posted online for the public to see. So if you're getting private information, that's a different question than if you're getting the public information. And this is the summary of the decision in 2014, the formal opinion from the ABA. You cannot send an access request to the jurors' electronic or social media. And frankly, if you do Google searches on just about anybody, or Bing or Yahoo, whichever search engine it is, you can find out a tremendous amount of information about people online. Sometimes they post it, sometimes other people post it. That's a whole separate training if you want to find out some more information. When I was an Intel analyst, I did a lot of open source searching because people were just sharing information online. If you want to know who's related to whom, first of all, if you're in a small town, just go to the coffee shop. But you can also look at obituaries that are online, and that will give you some idea of who family members are, who else they may be associated with, if you're trying to find information about that person, or who they may know or what they may know. Now, the other issues that have come up deal with judges and social media. Judges are able to engage in electronic social networking, but they have to avoid any conduct that would undermine the judge's independence, integrity, or impartiality, or create an appearance of impropriety. So they have to be very careful about what it is that they post. We've had cases which baffle me in which judges are either tweeting or posting on Facebook information about cases over which they are presiding at the time that they are presiding. And you would think that that would go without saying, that you're not able to do that, but apparently there are some judges who are not really thinking through what it is that they've done. And you may have friends on Facebook. We've also had a couple of cases and ethics opinions around the country in which there are a variety of different ways of looking at Facebook friends and Twitter followers. Essentially what they've said is that if you only have a few friends, that's probably bad for the few friends that you have if you're a judge. But if you're a judge and you have hundreds of friends, then each friend is worth a little bit less. So if you have a lot of friends, it's less of a problem than if you just have a few friends. So if you have lots and lots of friends, it doesn't matter if people are appearing in front of you. But if you are selective in who your friends are, it may be more of a problem if those friends are appearing in front of the judge at the time. This one I think is a good kind of a summary of judges who are using social networks. Best if they are not expressing their stance on professional legal matters. No using networks to obtain information on issues that they're handling. That's not information that's in the record, so they really have to be very careful about what it is that they're doing. No looking at the web pages of the sides of a cause that they're handling or witnesses in the cases. They should be making their decisions based on the information that's provided in the courtroom. No commenting on cases that they're handling. No responding to anything published about them. People can say really horrible things, but you really need to just let it pass if you're a judge. No uploading the legal opinions that they wrote. There are other places that can do that and will do that, but judges should not be doing that. No expressing political statements. They'll only be able to make private use of the networks. The judicial branch certainly has that. They actually have a very robust website that's extremely helpful, and they are posting the things that are appropriate to post, and we don't really need to have separate pages for Facebook or Twitter or Instagram or you name the social media site that covers their professional work. And the ethical rules for judges apply to their use of networks the same way that they do to anything else. So if you wouldn't put it in a letter, if you wouldn't put it in an email, you shouldn't put it on a social website either. Judge Clarence Goodman is sad that he has to defriend all of his lawyer friends. So that's the safe way to do it, and many judges choose not to engage in social networks at all, and that's probably the safest approach. If you do have that presence, you probably have to be very careful. The other issue that you run into is that if you have a social website, it tends to draw some flamers. So people may be posting things on the website that you don't particularly care for. We also have had, from our department, we've had a number of threats that have been posted on social networks, and we do investigate those. Often people are taken aback when they're greeted at the door with a group of people who are armed and carrying badges and sometimes having a search warrant. So those kinds of threats are taken seriously. If you have those kinds of threats made against you on social networks, either call your local law enforcement agency or call the Department of Public Safety. We don't have original jurisdiction at the Department of Public Safety, but we certainly have a lot of experience in a whole lot of different things, and if there are threats that are being made, they certainly should be taken seriously. So that's my presentation. I'll be happy to answer any questions that people might have about cyber ethics issues.
If you have questions, remember you can type them in the chat box at this time. Office 365.
Okay, the question is the use of MS Office 365, Outlook, and OneDrive compliant with the ethical rules? Actually, Microsoft Outlook has been pretty good about updating their security and providing adequate security. They do provide cloud storage, as I recall, and so if you are relying on cloud storage, you need to make sure that there is adequate security, and those are the kinds of questions that I think you really have to ask your IT people to examine to make sure that all of the information is adequately protected. And if it is cloud-based, the risks are certainly higher than if it's stored on a physical server someplace. But depending on what your standards are for storing information, I think generally it's going to be a good bet that the MS Office suite is going to provide at least the minimum amount of security. There are some additional, as I recall, there are some add-ons that you can also subscribe to with most of the Microsoft products. So I would make sure that when you are selecting whatever service it is, that you are asking the right kinds of questions and making sure that your IT people are paying attention to who has access to the information and how it's stored and what kinds of security are available with that. You can always add encryption as well. There are a lot of encryption programs that work well with Microsoft Office and a whole variety of other programs as well.
If you have a question at this time and you're on the web, go ahead and type that into the chat box at this time. While we're waiting for questions, I'm just going to remind everybody of the activity ID number also, 220831. That number again is 220831.
So I have a question. So I assume from the presentation that you're saying that if you get the consent from your client, that it's okay to send them information through email, not encrypted. But I assume there's some obligation still on you depending on what the type of information is?
I would be pretty reluctant to send information to the client that includes personal identifying information or other sensitive information without some kind of encryption. Even if it's just a simple password protected Adobe PDF, that's better than nothing. And I think it's important to make sure that the client understands what the risks are. So sharing that information, I mean, it's certainly an option, but at this point, given the risks that we know about, I would be very reluctant to share information without some level of password protection or encryption.
And I've got a technical question. I'm not sure if you can answer this. So if you're at home and you have Wi-Fi and you do have the ability to work at home, is it safer to use an actual internet connection as opposed to the Wi-Fi with the computer, or does it make a difference?
As long as you password protect everything that's related to your Wi-Fi, then it's fine. The problems you run into a lot of times is that you not only need to protect however it is that you get your Wi-Fi, but you may also have a router that would cover more than one device. And you need to make sure that your router is also password protected. So I know we had a child pornography case in which we went and served the search warrant at the home, and it was a couple that did not know anything about technology. It was very clear. They really did not understand what was going on. They had password protected part of their system, but they had not password protected their router. And so the individual who actually was downloading the child pornography to his computer was accessing their router in order to be able to download the information from outside of their home. So it's really important that if you're working from home, that you have enough knowledge of the system that you're providing the kinds of protection that will not allow anybody to just access it without a password or without some kind of device to unencrypt it.
I don't have any questions at this time. Roxanne, in case if somebody would have a follow-up question, do you want to give them your email address?
Sure.
In case they think of something.
My email address is roxanne.ryan@iowa.gov, and it's ROXANN. There's no E, so it's roxann.ryan@iowa.gov.